In today's lecture of e-commerce, we will discuss some of the legal issues in e-commerce. We will cover the topic intellectual property protection like copyrights, patents, trademarks, and domain names. So, what is this intellectual property protection? Intellectual property rights are the legal rights that cover the privileges given to individuals who are the owners and inventors of a work and have created something with their intellectual creativity. Individuals related to areas such as literature, music, invention, etc., can be granted such rights, which can then be used in the business practices by them. So, the types of intellectual property rights are copyright, patents, trademark, domain names, database rights, performance rights, decision rights. So, all these are the type of intellectual property rights. Now, what is copyright, trademark, and patent? This is a very beautiful slide, which makes the differences between the copyright, trademark, and patent very beautifully. What is copyright first? Protection is automatically granted to the author for the original creative and intellectual work. And trademark, this is a brand element which distinguishes your goods and services from those of your competitors and other traders. And the patent is this concerns obtaining protection for new inventions that are new, original, and useful. So we can easily identify the copyright, trademark, and patents in some books. There are so many literatures and there are so many movies which are all copyrights. So we have seen the copyright protection there. And trademarks. When we do businesses, every business community, maximum business communities are having their trademarks. So these are basically used for the businesses. And patent. If you are a scientist and you have invented something, then you must get the patent, and that is a very unique in the world, which is nothing nowhere elsewhere in the which is nowhere and elsewhere present in the world. This is only developed and invented by you, and it becomes the patent. So the copyright are like this, uh, like books, lecture, dramatic and musical works, cinematography, drawings, paintings. All these are the copyrights. The rights to distribute copies or phone records of the work to the public by sale and other transfer of ownership or by rental lease. That means we need to if I want to use now if I like the idea or if I like some music of which is a copyrighted. Now I want to use that music for my own purpose. I have to purchase the copyright price from the actual maker of that music. Okay, and validity is registration not mandatory but recommended, valid through the lifetime of the author and 60 years after his or death. So honor has protection in most countries. So these are the uh, differences. These are the features of the copyright protection. And in trademark, these are the marks, word mark, a logo mark, or a slogan, shapes, and unconventional marks like colors, sounds, gestures, animation, holograms, etc. are also registrable as a trademark. The rights of the trademark are exclusive right to use a mark and prevent anyone from using it without permission. It also gives the owner the right to license, assigning, and sell the mark in return of some compensation. And the validity 10 years, which can be made perpetual as long as renewed every 10 years, should be applied separately in every country in which protection is required and has marketed. So this is all about the trademarks which are used only for the business purpose. Then patent. Patent is invention will be patented if novel or original has an invented step and has some industrial application. The rights to the patent are exclusive authority over the patented invention, right to exclude others and exploit the patent and earn from it. Then validity patent protection is territorial right and therefore it is effective only within the territory of India. Separate patents required to be filled for each country. where protection is required. Patent is valid for a period of 20 years, after which it goes in public domain. So the patent life is for the 20 years, and after the 20 years, now it will be free. Anyone can use that patent. So this is all about the copyright, trademark, and patent. The next is copyright versus trademark versus patent. Now another difference of this is governed under the Copyright Act 1957. The trademarks are governed under the Trademarks Act 99, and the patent governed under the Patent Act 1970. The types of protection in works: the protection of only creative expressions like literary works, artistic works, dramatic works, etc. So copyright is limited to in this manner only. And in trademark, it is a protection of unique name that makes a brand distinct from other. Can include names, slogans, logo, shape, color, etc. That's why many businesses are having their own logo, their own slogans, and in patent, production of invention that are novel, original, and has industrial utility. The validity and reach: the validity for lifetime of the author plus 60 years after his or death, and protection available in most of the countries in the world. And in the trademarks, the validity for 10 years can be made perpetual by renewing the trademark every 10 years. So territorial in nature, to claim rights should be applied to each country individually. And patent is having a validity for 20 years starting from one day from the day the application is first made. It is also a territorial right, and therefore it is effective only within the territory of India. Separate patents required to be filed for each country where protection is required. Now, secures copyright secures creative or intellectual creations. Trademarks secure the branding under which products and services are sold, and patent secures inventions that are useful for the world and have some use. So this is all about the copyright, trademark, and patent. Another application in the provisional application requirement in the copyright is no provisional application required. In trademarks, trademark registration does not include provisional application, but it requires a trademark search. And in patent, a provisional application gets you 12 months of time to file a complete specification and a priority date claim. Then symbolic representation is what? No symbolic representation to show registration. And trademark used when registration is in process, that is TM. We have used this. And used when registration is complete, this is the R. We have very frequently seen these symbols on the product or in companies website and logos. And for the patent, no symbolic representation to show registration. Now, intellectual property protection, domains name. Domains refers to the unique name that identifies an internet site. Domain names have two or more parts separated by dots. For example, www.askedit.com or www.vcpsks.com. Okay, the term domain name has multiple related meanings. It identifies a website on the internet. Example, company.com, also referred to as URL or Uniform Resource Locator. You all are very familiar with the domains and the websites. It allows reference to internet sites without knowing the true numerical address. It refers to the official name of a computer connected to the internet. It is a unique name of a computer on the internet that distinguishes it from other systems around the world. So these are sometimes colloquially referred by the marketers as web addresses. Then trademarks and domains names. A trademark is used to differentiate business from competitors. The owner of a registered trademark has the exclusive right to use the trademark in relation to the goods and or services for which the trademark was registered. This includes in a domain name. A trademark registration may also protect domain name if domain name contains a trademarks. So these are the advantages. This is our trademark and domain. And this is the reference from which we have got this text. And in the next lecture we will study about the privacy and security and role of governments and regulatory bodies jurisdiction issues. Till then, thank you.